Hi, and welcome to our Meet the Pros event tonight. We are welcoming David Kazemba from Overcast Law offices here in Wenatchee. My name is Beth Sykes. I'm the teacher in the Wenatchee Valley Community Transitions Program, and we are here tonight with Tina Gorman from Eastmont and Tamara Burns and Jared Gronin from the County DD office. We are excited to have David back. He has come here several years now in a row to speak about guardianship, and we're just thrilled to have him back. Before we get started, I wanted to let everybody know that is in person. You guys do have a microphone on your tables. They are set to the off position. If you have a question, you will need to push the button so that the green light comes on, and then speak your question into the microphone so that everybody online can hear your question. Please make sure that you do push the button after you speak so that the sound does not get picked up from your table for the folks online as well. Also, if you're in building, there are restrooms to the right of this desk out in the hallway here if you need to use the restroom. And with that, I'm going to send it on to David.
Yeah, might as well. Good evening, everyone. Special thank you to Beth and Wenatchee School District, Eastmont, for having me here. I have given this presentation a couple times, so I'm hoping this is not repeat and you all will have something to take away, and there'll be questions as we go along. I'm very familiar with what's behind me, so it's really for you all. So feel free to stop me. Feel free to ask your questions. This is an opportunity for us to learn. From me, from you, and from you, from me. And I'm going to go ahead and walk through my slides. If there is questions, go ahead and just let me know. I'll pause and we can answer the questions and come back to it. Depending on what we have online, we may ask you to repeat the question or any of that. We'll make sure that everybody gets the same information and we can walk through this. But let's have some fun with it because it's kind of a dry concept. So I'm going to go ahead and remind people. Okay. And I was told to remind that people on Zoom, if you have questions, feel free to unmute yourself, ask your questions. Maybe I have a question or something like that before you get started, but you can ask questions as well, and we can answer that as we go along as well. Okay, so let's go ahead and get into it. We're here to discuss guardianship and alternative arrangements. Of course, I'm from Overcast Law Offices. We are a law office, small boutique firm in Wenatchee, Washington. We're down in the Morris building. My practice areas are guardianships, estates, wills, trusts. So I help people put together plans. Some of those plans work very well. And when we get together, we can try to make sure that all the documents talk together and we have an understanding of what happens in the events things happen to us. Okay, perfect. Couldn't be a talk with an attorney without going through the disclaimers. So a couple things. We are live stream. So I've given this presentation a number of times. Sometimes there's some personal questions that come up. If you don't want that on the World Wide Web, save that for after. If you have a question that you think is applicable to everyone, by all means, please ask me. The other thing is this is not legal advice. Usually what happens in my office is legal advice. That's applying law to facts. What I'm giving you is kind of what I call my bookend law, some broad strokes so you can think about, is guardianship necessary? Is guardianship something that I need to talk to an attorney about? Just to give you some tools, to give you some general information so you can start making some decisions of whether you think it's something that applies to you or not. The other thing is the views. Some of my views may not be the same as the district or other entities that are a part of this. So just be aware this is for your information, and I'm here to answer your questions and help with the understanding of the subject material. So I had an old professor that said, go ahead and tell them what you're going to tell them, tell them what you're going to tell, and then remind them what you told them. So that's what we're here. We have an introduction. This is what I hope we're going to be able to answer by the end of our night. First, what is capacity? What is incapacity, substituted decision-making, power of attorney, guardianship, whether it's necessary? That's a big question I get asked a lot. Who can be the guardian, and what is the guardianship process like? Everybody with me so far? Okay. So in order to determine if we need a guardian, we have to determine what does that mean? Well, as adults, we all interact with the world through contracts. We get married, that's a contract. We sign up for a credit card, that's a contract. We decide to purchase a home, that's a contract. Most of how we interact with the world is through contract. So our capacity is our level to understand the contract that we're entering into. So I understand if I sign up for a house that I have to pay on the house or they can take my house. I understand if I sign up for a credit card that I have to pay on the credit card. Same thing with the marriage. I understand if I get married, I own an obligation to my spouse. Those are all things that as adults, we understand the benefits and the risks of going or entering into that contract. So capacity is a legal determination and the ability to make rational decisions about one's care or finances. So we do this all day, every day when we interact with the world. So the flip of that is, what is incapacity? And incapacity takes a couple different forms. Incapacity in simplest form is the ability to not make rational decisions about your care or finances. Maybe you don't understand that if you decide to purchase a house, that they'll take the house back. Maybe you don't understand that you're going to have to make payments if we get a credit card. You don't understand the benefits and the risk of a particular action. So the old law was that incapacity was a legal determination, and it was a significant risk of harm due to the inability to make decisions for healthcare or financial purposes. The new law, and this is again provided in the statute, is lacks the ability to meet essential requirements for physical health, safety, or well-being due to the inability to evaluate information. So that is a kind of a newer spin that's been put on the law. It's not whether you understand, it's whether you can understand that being broken down into simpler terms so you can receive the information and then make a decision. So the goal and the nexus between the old law and new law is, what are we offering to people at their level so they can evaluate the information being received? Any questions on that one? You guys completely understand it. You can teach this subject afterwards. Great. Okay, so with those two concepts, we now have to think about, okay, what happens if somebody needs to step in and drop their water bottle? So substituted decision-making is where somebody is substituting their decision for somebody else. So these can be voluntary or these can be involuntary. So where we typically see a substituted decision maker is in a power of attorney. So that is a voluntary grant of power. Somebody says, I want you to help me make decisions in the event I can't. We have the informed consent statute. This is medical. This is in the event there is not somebody who can speak to what needs to happen in the medical facility. There is a pecking order of people that need to, the doctors can look to help make decisions. And then, of course, then we have the guardianship process, which we'll get to some of that as well. That's a legal proceeding. And what we're doing is we're appointing a decision maker, a legal decision maker for an individual. So the term substitution decision making has kind of fallen out of favor. A agent acts on the benefit of the individual. So that person takes the wishes as known from the individual and effectuates those. So this is what I want you to do, go forth. And if you don't know what I would say to this, here's what you know about me and how I would react to that situation. The other situation is we have this concept called the least restrictive alternative. This is something that is huge. It's actually in the forms and it's in the statute now, is that we have to check the box that we have considered or tried other opportunities. So guardianship is not the first step. It is the second step. It is the decision we've made because these other options may not work for us. Okay, and I kind of went over this, a least restrictive alternative. That's the, what have we done in the meantime? So this is a situation where maybe a durable power of attorney could work. In the Social Security context, maybe it's a representative payee. In trust situation, maybe it's a trustee or something like that. Is there something else that we can do instead of looking to the guardianship? Because we have to tell the court, hey, we've thought about or we've tried this other thing and it either didn't work or it's not going to be sufficient enough to do what we need to do. Okay, so this one has changed a little bit. The first time I did this, I had a little picture, a little power button on there. So I've moved away from some of the silly GIFs and slides and stuff like that. But power of attorney, I'm only going to give you one pun. I'll try to stick to one or two through the night. But a power of attorney is typically we make it durable. And we don't make it durable by putting it on really thick cardstock. No, it's durable because it is it survives incapacity. So what happens is it is a piece of paper. Typically, you go to a lawyer's office for this, and it's you are appointing somebody to act on your behalf in the event you can't speak for yourself. So this is if you are, leaving the country, you need somebody to do something for you legally or for real estate. This could be you're in the hospital, can't speak for yourself, and you need somebody to step in. So that's what a durable power of attorney is. It's appointing an agent to act on your behalf in the event you can't. It's a product of contract law and it's a product of agency law. So for contract law, it's basically contracts are construed narrowly. What you put in there is what you get. The uniform laws have changed some of that, but usually, the power of attorney that you get from me is much longer than, say, some other ones, because I want to make sure that I give you the powers necessary in the event there's a problem. The other is it's a product of agency law. So an agent has to act in the best interest of the individual. So if you're granting this right to somebody, they're the ones who are going to step in and do what needs to get done based on writing checks for bills, taking care of things at the bank, making healthcare decisions in the event you cannot. Any questions about that one? Okay. So go ahead.
Well, I got a couple of mix. So if a person doesn't have the capacity to grant that power of attorney, can there still be a power of attorney? Are there some restrictions on the ability of someone to grant it?
Yep. So a power of attorney, you have to have capacity. You have to understand the risks and the benefits of what you're entering into. So if somebody cannot execute a power of attorney, they don't have the capacity to do so, then we have to talk about these other options. So now we're going through the informed consent statute for healthcare purposes, and then eventually where we're going to end up is guardianship. And guardianship is typically if we don't have a power of attorney, we don't have a voluntary grant, we have a legal proceeding that allows us to get somebody appointed to make those decisions. Good question. So the informed consent statute, this is for healthcare decisions. So the doctor, the medical facility will usually walk through and try to the extent they can, interact with the individual, the patient, to make decisions. In the events that that individual does not have the capacity to make those decisions, there is a pecking order, and you'll see some of the same language in the statute that I've highlighted there that's in the guardianship statute. The demonstrated inability to understand and appreciate the nature and consequences of the action. So do you understand this healthcare risk? Do you understand this surgery means X, Y, Z? And if they can determine that you understand that, then you've met that standard. But if they determine that you cannot, and they're the ones that get to decide that, they can lean on other people that are involved. So who are those people? So here's our pecking order. So the first one up at the very tippy top is the guardian. So that's kind of the rule stops or the buck stops there. So the guardian is the first person that outside of the patient that the doctors will look to. Then you go down the line. So the next is power of attorney. Spouse, children, parents, brothers and sisters, so on and so on and so forth. I can tell you that usually the medical facility will stop probably right around subsection 5 or 6, but they'll keep looking to who is the one that's going to help with these decision making. So in the event there is a situation where they're like, well, we don't have a guardian in place. Well, there is a pecking order that says these are the people who can help with this healthcare decision. Okay, now we're at the meat and potatoes section. Why we're all here. What is a guardianship? So a guardianship is the legal proceeding in the event we don't have this voluntary grant of authority to make decisions. We need a court situation where we can appoint somebody to make legal decisions. Okay. So the law has went through some changes, and the most recent change was the Uniform Guardianship Act. And the Uniform Guardianship Act is not necessarily uniform. There's actually a very few amount of states that actually have adopted this. What it did is it's changed our guardianship law that we've been practicing for a number of years, but the case law and the thrust of what the court does in these things has not changed. So this was effective January 1, 2022, and completely overhauled the system that we were working with guardianship. But the goal of this new act was to create a kinder, gentler guardianship, to give more notice, to make sure that things are happening so people are aware, and that also it's given an opportunity to the individual or the respondent now, the opportunity to say, hey, there's something I don't like, so I have an opportunity to speak up. I don't have to go too far, but Free Britney movement, all of those things kind of help stem this thought that if there is something wrong with the guardianship, the respondent needs the ability to say, hey, there's a problem, and have an immediate remedy to go back to the court to speak up. So history on this. So before this, we had 1192 and 1188. This has been in effect for decades. Minors. So what happened with the new change in the law? So now minor guardianships are all under guardianship. It used to be this was non-parental custody. Changed some terms. There's some additional disclosure requirements that I'll go over, and notice. So positives, person-centered. We're all about person-centered. Guardianship is not a one-size-fit-all. Shoes are not one-size-fit-all. We got to find the right shoe that fits you. We got to find the right style that works for you. Maybe it's a limited guardian. Maybe it is a guardianship over a limited subset. Maybe it is financial. Maybe it's a conservatorship and not healthcare decisions. Maybe it's healthcare decisions and not a conservatorship. It's not one fit. It's not one fits all. The other thing that's important with this new law is the rights and interests of the individuals. The rights and interests of the individual is paramount. The whole point of the statute, the whole point of the guardianship process is to protect the individual. That's why we have reporting. That's why we look to the least restrictive alternatives. So there's two types of guardianship. There is a guardian, and then there's the conservator. The old law, it was just guardianship. And you had the guardianship of the person and guardianship of the estate. Now we have the two different terms. A guardian is one who makes medical decisions. A conservator makes financial decisions. Funny story about this. I actually had a case before the change in the law where I had a insurance company that was saying we needed a conservatorship. And I said, there is no conservatorship. There's no conservatorship. Well, guess what? Now there is. So they were sort of right. At least not then though. Okay, so there's that standard. So what are the rules that we're playing by? So if we're going to ask the court to establish a guardianship, we need to prove that the respondent lacks the ability to meet essential requirements for physical health, safety, or self-care because of the inability to evaluate information. And there, see, that's that extra piece again. And that we also have to prove that the individual's needs cannot be met by a more least restrictive or protective arrangement. So those are the two boxes that the judge needs to check when making a decision. Okay. Guardianship law is very standardized. The point of having a uniform Guardianship Act is that it's uniform. So going across the state, they all should be the same. The forms are the same. The decisions the court needs to make should be the same. Now, I can tell you, being in different counties, that there is a little bit of a difference. However, largely they're the same. And we have mandatory court forms that everybody uses. And you can adjust those forms, but the goal is that everybody is using the same forms, using the same rules, so everybody understands what we're dealing with here. There's no surprises. Can you hear me? Okay. All right. In addition to that, we also have the petitioner's disclosure. So this is something that's newer. So before accepting an appointment of a guardian or conservator, a person shall disclose whether they've been a debtor in a bankruptcy proceeding and whether they've been convicted of a felony or a crime involving what we call moral turpitude. So the moral turpitude, that hasn't changed. That's always been there, but the disclosure of a bankruptcy and stuff is newer to it. This is, again, the goal is to protect the individual. And even if you were a debtor in bankruptcy, it's not an end all be all. It's just an additional disclosure so the court can make a decision and know that the person who's petitioning is the right person to be the guardian. So when we talk about guardians, there's two types of guardians. There's the lay, or what I call my friends and family guardians, and then there's the certified professional guardians. The certified professional guardians are the ones who went through training, and they're the ones who actually get paid to do the job of guardian. I can tell you there's the amount of guardians in this county are getting less and less because most of them are getting older. But they're still out there, they're still available. They're really, really great as far as the rules of the road. They know what the reporting is, they know what needs to get done. The difference is they're not going to know the individual as well as the friends and family. So then we have our friends and family guardians. So this would be you all. Typically what happens is I have parents petitioning for guardianship of their children that are going to turn 18. And once a individual with limitations turns 18, they're still an adult, just like the rest of us, regardless of their limitations. So we need the assistance of the guardianship process to make those decisions and help that person on interact with the world, whatever that looks like for them. So friends and family guardians must take online training. There's a portion in this on the web. You take 2-hour class and you sign a declaration saying that you took the class. So that's to teach you what the rules are. The friends and family guardian are subject to the same rules as the CPGs. So regardless of not, this is why most people will get an attorney, is because they expect you to know the rules, whether you know them or not. And then also the large part, the benefit of the friends and family is they know the individual's wishes. So we talked earlier about agency. So the individual who knows that person best is going to be in the best position to make decisions based on what they know that individual, their wishes or their needs might be. So in order to talk about guardianship, we have to talk about what rights could be taken away. Largely, we're talking about the right to contract. So what you're doing with a guardianship proceeding is you're taking the legal decision-making authority away from somebody and vesting it in somebody else. So here are some of the rights that could potentially be taken away. And like I said earlier, it doesn't have to be a one-size-fits-all. So if somebody understands how to vote, that may be carved out. But again, it's an opportunity. It's another way that we interact with the world, and it's a right that may or may not be taken away. To marry, to possess a license, to buy, sell, lease property. All of these things are things we need to consider when we go down this road. And what we want to do is, if there is a guardian appointed, that person needs to be appointed with the authority to do it. So that's what these rights, what we're vesting that guardian with. Court visitors. So go ahead, Tamara.
So on those items that you listed out, how would you know which ones each guardian has the authority to invoke or revoke?
Yep. Great question. So those are the rights that are taken away from the individual. The order appointing guardian would list out the authority. Most of the authority is vested by statute. So it's essentially what they need to do to get the job done, but it depends on whether they're a conservator or a guardian. So if they're making medical decisions or they're making financial decisions. You have a question? Okay. Go ahead.
So if someone has a guardian, can they still get married if the guardian is okay? Or is there some other limited kind of marriage that's like a union that could happen?
Yep. Generally, marriage is a right that's taken away, because usually in a situation where appointing a legal decision maker, that's a right that has some very dire consequences or has some very lifelong consequences. So if there is a guardian appointed, and that is something that maybe the respondent or the individual is interested in, maybe that's something that's changed, we can always go back to the court and ask to adjust the guardianship. We're going to have to come up with a reason why and explain how this individual understands the benefits and risks of getting married. But the new law gives us the opportunity to go back to court and say, hey, we need to reevaluate this.
So kind of on that same note, because I saw like social interactions and social activities, like how far can that go? I'm just thinking about like Special Olympics, social events, dating, going to a dance, being in a relationship. Could it prohibit all of those?
Yep. Great question. So that's a checkbox on the form. However, when I tell my clients when we're doing this, I tell them, guess what? The individual is still a person. And there's certain things that the guardian can do and certain things that the guardian cannot do. Sometimes, we're coming in from the parent and we're wearing our parent hat and we have to put on our guardian hat. The individual can still make decisions about their social well-being. Now, if those social decisions are harming them, then the guardian can get creative and say, this is not a good idea. And even can say, this is not a good idea. No. Before this law changed, there was another statute that was the right to associate. And I had an opportunity to litigate some cases under that one. And the individual subject to a guardianship can associate with whomever they want. And unless there is a protective order or some reason, usually a level of harm, they can associate whoever they want to. So if a guardian is going to limit the right to associate, there should be either an order in place or a demonstrated need, a reason of harm for why you're limiting the association. So if they don't check their person at the door when they become subject to a guardianship. Good question. Anything else? Oh, awesome. So when we file a petition for guardianship, once we get all the paperwork filed, the next step is a court visitor is appointed. The court visitor, the old terminology used to be guardian ad litem. So we don't use guardian ad litem anymore. That has a different term now. Court visitor is the one who investigates the issue. They'll request medical records, and their job is to make a recommendation to the court whether a guardianship is appropriate, and two, that the petitioner or the individual who's asking for the guardianship is the proper guardian. Sure.
So the court visitor asks, because when I look on it online, they want something from the doctor and something from a psychologist and something from somebody else. And the court visitor asks for those. That's not something we have to ask for.
Great question. So the court visitor needs medical records, and they will rely on information. They'll make interviews. They'll get the information to make their recommendation. Generally, a court visitor will get the records. However, it's very, very helpful for my clients sometime if we ask the court visitor to put together the form, and then the individuals go to their doctor's appointment and have the doctor fill out the form at their appointment. As long as it's done close in time, that's a great way to get the information without having to go through the song and dance of the letter. So we send a letter, say, please fill out this form. Guess what? It's going to happen. It's going to sit on somebody's desk for a little bit. And in the guardianship process, it's actually fairly quick. You want to have the hearing within 60 days, which in my world, in the legal world, that is astronomically fast. So we want to be able to help the process move along. And that's one of the ways that we've kind of came up with to help with that process, because if you get the doctor to fill it out during the appointment, it's helpful because you're there. And it's also helpful that that information can then be turned over to the court visitor, and it's an easier way for them to get the information so they can put together their report. Here's some additional things that must happen. So the court visitor has to interview the person. The court visitor has to interview the proposed guardian, and the court visitor will also look to other people who may have a stake or an interest in that person's life. Guardian ad litem, I told you there's a different term of that. So a guardian ad litem can still be appointed. Generally, when I see this now, this is when we're talking more about the minor guardianships. This is somebody who's representing the interest of the individual. These ones don't happen as much with the adult guardianship, but sometimes the terms still get interchanged. So I want to make sure that we understand the distinction between those two. Okay, so in most guardianships, what will happen is the county will create a list, and the list of the court visitors. So the first call is to the court and say who's next on the court visitor list. And they'll go ahead and list out the court visitor. Then it's usually a telephone call from my office giving just a thumbnail of the case and indicating if the individual has any conflicts and whether they're willing to serve in that role. If they do, the next step is to get an order appointing them. And once the order is entered, then the court visitor has to file a statement of qualifications and their job begins. That's when they will go out and either connect with the individual or connect with the proposed guardian to make arrangements to meet with the individual and do their part to investigate the issues and then make a recommendation to the court. So the hearing on the petition, I already said this earlier. So typically we want to set these out 60 days. The reason doing is because the judge can dismiss the case after 60 days if it's not moving forward. Because again, the goal is to protect the individual. And if you're not moving the case forward, judge can say, okay, we're done here. So generally I like to put it out 60 days, again, because it keeps the court visitor on the timeline so we can move the case forward. At the hearing, typically what will happen is it will be the individual petitioning for guardianship, it will be their attorney, and the court visitor will show up at the hearing. Whether the individual wants to appear at the hearing, they have a right to appear at the hearing. Whether they appear at the hearing can be waived for cause. And then usually the judge will indicate that they've reviewed the petition, they've reviewed the court visitor's report, and then they will make a ruling based on what the situation is, and they'll decide, is a guardianship appropriate? And is the petitioner or the individual who's asking for the guardianship the right guardian? So after the hearing, this is where the fun begins. So guardianship is kind of a lifelong process. So you're saying, I'm going to step in, and largely it's going to be for that individual's lifetime. So guardianship process doesn't end with appointment. There's further reporting that's required. The reason being is to protect the individual. So you will have a yearly reporting requirement. Maybe it's a triennial reporting requirement, but there will be some reporting requirement imposed. You will also have to file certain reports. So we call them the 90-day report. Those are the inventory, if there's assets involved, and the personal care plan. And the personal care plan is, what is the plan to take care of this individual? I really like that stuff to be filed and to be as explicit as possible, because in the event something happens, so something happens to the guardian, we can all go to the court file and figure out what is the care needs for this individual, who's next in line in the event something bad happens. So it's really important that the guardian conservators understand that it's not you're appointed and then you're done. It's you're appointed, now you have this obligation to manage the care or finances for the individual. So what decisions can a guardian not make? So we already talked about the social aspects. Some of the other things is we cannot involuntarily commit somebody. That's a different statute. And we can't place somebody in a facility against their will. Again, individual is a person, but we can help that person make the decisions based on what we know their wishes to be. And in the event there is a risk of harm, we have the remedy of going back to the court or helping to lead that individual to make the decision that's going to be in their best interest. Notice. So some good things with this, the notice scope for the old guardianship and the new one expanded. This is a fantastic opportunity for other people to be involved in the individual, because we all know it takes a village. So it's not just one person, and it broadens the scope of who either might be entitled to notice or who might have a stake in the individual's life and have something to say about it. The other notice is the notice of the reporting. So the respondent has an absolute right to get a copy of the order appointing guardian. They also have the right to receive notice for the plan. The plan, again, is the care needs. They also have a right to a copy of the reporting. So every single year or every 2 years or every 3 years, whatever it is, reporting goes in, and then there will be a copy sent out to the individual. So it's so everybody's all on the same page. There's no surprises. Everybody's rowing in the same direction.
So how would that work if, say, there's a parent with a child that is the guardian of the child and they all live in the same address? Would all the mail and documents go to the same, obviously the same location? So
They would go to the last known mailing address for each person. So if that's the same house, and I've had that, families will get 5 packets. So it is what it is. But the point is obviously if you're getting 5 packets in the mail, somebody's going to pay attention and say, okay, this is great. Either this is phenomenal, or now we know we have an opportunity to adjust and do something. So yes, if the same address, they'll go to the same address. So hearings that are part of the guardianship process, first is the petition. So the petition is what starts the process. And then we ask the court to make a decision to enter an order appointing the guardian conservator. We have the guardian's plan. That's the care needs. We also, as part of that, will put together a petition for a budget. So guardianship, conservatorship can be very mechanical, and it's just a process of learning the new language and then getting into a spot where you know what you're doing. And then it becomes like clockwork, just going through the reporting. The guardian's report, this is due every year, 2 years, or 3 years, depending on what the court decides. It's a lot easier to deal with 12 months worth of information rather than, other reporting requirements, but it's to report to the court, here's what came in, here's what went out, here's the situation. So everybody's on board with what's going on in the individual's life. And everybody understands that everything's done for the care needs or the benefit of the individual. Okay, just talked about this, the guardian's plan. This is the care needs. So I'm a big proponent that this care plan should be as explicit and be as clear as possible. So again, we know in the event something bad happens, what are the care needs of this individual? And the report could be 2 years, 3 years. Generally, 1 year is standard for the first report. This includes a snapshot of any changes in the person's care needs. It includes an updated budget if we need to adjust. It also includes a balance sheet, which is the meat and potatoes and probably the frustration of all my clients is putting in and making the numbers work, because some of us are not accountants, some of us have other professions, but it's an accounting situation that's submitted to the court for approval to show them what's happened in the guardian's life. Who can request a copy of the report?
Yeah, I'm curious because we have so many individuals in our adult system that do have guardians that it could be very helpful for like a provider, a residential provider to have a copy of the plan, just knowing like all those goals that are outlined. And I didn't know if it's something that people could request through the guardian or how that would work.
Couple different ways to look at that. Any guardianship proceeding is public record, subject to certain documents being sealed, personal sensitive information about medical and the like. Guardians, the court visitor's report is generally filed under seal, but a plan is not. So that would probably be my first step, is say, if you want a copy of it, go get it. Whether you could request that from the guardian, they may or may be looking at it from a different lens. That might be a way to request. But any guardianship proceeding, if you have a case number, it's public record. You can go to the clerk's office and go get it as long as it's not sealed. Yep. Couple new additions I want to cover in the statute, may not apply in this situation, but I usually get some good discussion when we get to protective arrangements and supported decision-making. So I want to at least walk you through it. So in this new statute, there's also a section for protective arrangements. And what is a protective arrangement? Protective arrangement is whatever we can come up with that's not a guardianship. I mean, that's the simplest way to think about it. So this is where the court is blessed with a substantial amount of power to do equity, to do what is right. So maybe we don't need a full-blown guardianship. Maybe we just need a narrow situation. So maybe this is protecting an individual for a short amount of time. Maybe this is appointing somebody as a trustee. Maybe this is somebody who has a power of attorney for one, but not the other. It can be literally across the board. What I can say, though, practically is to find this one size fits all. The court could probably make an order, but when you get to guardianship, when you start talking about guardianship, it's not usually the individuals who are asking the court for the guardianship that's the issue. The issue is we typically have an outsider, a third party, an agency, a financial institution, a medical provider who says guardianship is where we need. And they're looking for the letters of guardianship, the letters of conservatorship. That's your authority to act. This protective arrangement doesn't do that. It gets close. You have a court order, but it doesn't vest authority like a guardian or a conservatorship does. So it gives people like myself, it gives the attorneys the ability to be flexible and come up with creative solutions, but sometimes practically it doesn't work out with what the goal or the need of the guardianship is. Okay. Here's a couple that are provided in the statute. So a couple different arrangements is authorizing a direct transaction, particular medical treatment, restricting access to a place. Again, this is that risk of harm that we were talking about, and reorder other arrangements. This one is actually kind of an exciting situation, as we're going to talk a little bit about the decision-making, the shared decision-making model. This is a new portion of the statute. I've looked at it, I've spoken on it. When this first rolled out, this was actually over in Europe for a long portion of time before it ever came over here. It is a great idea in theory. It's really hard to work out in practice. So what this is this is a supported decision-making model. And what we say is we can create this agreement, we create this model where we can help somebody who may not fully understand a decision to reach a decision. And we can create this agreement that says what we're going to do. Sounds really, really nice, sounds really great. The problem is in practicality, it's hard to maneuver. Because again, you'll have those agencies, those third parties who say, I want to know who's in charge. And a supported decision-making is not who's in charge, it's helping the individual make the decision. We have a couple people that are disqualified, so they cannot be persons who are acting as a supporter under this model. So it can't be an employer, it can't be somebody who is providing services, and it can't be anybody who has an order of protection against them. So that one's pretty obvious. But if you look at the other two, it's really somebody who has a financial stake in the decision. That's what we're trying to limit. We're trying to help the individual make decisions, but not make them for them, and then also not make those decisions that would probably benefit the supporter involved. So this is actually provided by statute, so anybody can go look at it on the statute, and it's name of the person, make this agreement on my own free will, and then here's the decisions that this person can help me make. And you can kind of fit it into how it works for you. And then you can also tell what the decisions the supporter is not able to help with. As part of this, usually we're thinking about this, we're talking about the medical context. So we also have to have a release of certain records. So we've heard the term HIPAA. HIPAA is the medical that allows the medical facilities, the doctors, to communicate with other parties besides the patients. So there's certain releases that's built into this agreement that will help with some of that. This is the one thing I always want to highlight. If you are going to use this model, please be aware, because some entities, some people that will interact with the individual are mandatory reporters. So if you are walking around with this agreement saying, I'm supporting this individual, and they say for whatever reason that it doesn't look right, smell right, what have you, they may report it. And it may be a situation where they say that the individual is being taken advantage of. This says that a fact that the individual has done this is not a per se situation, but it just kind of opens the doors to certain things. So I just want anybody who's going to do that, maybe link up with an attorney and walk through that decision, because this is one of these things that is an amazing opportunity to help somebody make a decision, but it may not be the best thing in practice. And I guess that's the great thing about law. What I do is, the law says you can do something, whether you want to do it. That's what we come to attorneys for. So, done a whole lot of talking. I was hoping for a bunch of questions here. So now is your time. I'm here for you. We've covered a lot of law in a short amount of time. So please let me know what questions you have, how I can help kind of your understanding of this topic area. No questions?
Is it so complicated that somebody can't do it by themselves, or do they have to have an attorney?
Great question. Can you go it alone? So there are mandatory forms involved. There's also, in every single county, there are what's called court facilitators, and their job is to help people with forms. They're not attorneys, but they can help you fill out the form. Now, being an attorney, I would never recommend somebody do that, because what you're doing is you're agreeing to play by the rules, and you may not know what all the rules are. So I would encourage you to talk to an attorney about it if you're thinking about it, but do you have to have an attorney? No, you don't.
Yeah, some friends of mine, their son has some mental disorders, but he got in with the wrong crowd and he's pretty gone on drugs now. Would you suggest something like this for them?
These are the kind of questions that I get fairly daily because the facts may not fit in a traditional model. So if there's somebody who's not making good care decisions for themselves, that may be an opportunity for guardianship, but that may not be the most immediate concern that we need to deal with. If there's drugs involved, there's law enforcement that's involved. So there's a whole host of additional questions. In my world, we call it issue spotting, that we would want to ferret out before making a decision of whether that's the way to go. But if that person does not have a decision maker and somebody needs to step in to help that person make decisions, that may be a viable option.
So weird questions. If you've seen an individual that got a guardianship, a full guardianship over them as a minor and now as an adult and are questioning whether or not a guardianship is the appropriate route for them, can that individual petition to have it revoked?
And when we talk about individual, are we talking about the guardians? Or are we talking about the individual subject to the guardian?
The individual subject to the guardian.
So that's another kind of interesting factual scenario. So the individual subject to a guardian, if we're assuming the fact pattern is that individual, the guardianship was established as a minor guardianship. Well, by operation of law, that guardianship will expire at 18 or whenever that's, whenever the age of incapacity is exceeded. Sometimes it's not at 18, but whenever you get past that hurdle, done. And then whether that guardianship needs to continue, that will be probably either a discussion for the guardians to make, or if the individual feels that they're ready to give it a go, what other opportunities, because the only thing with a minor guardianship, the reason for the incapacity is just because they were underage. So maybe they understand the benefits and risks of a particular transaction. So that would be a opportunity for further discussion to determine, do we need to keep going with this, or whether the reason for the legal proceeding has now stopped. It's over with. So good question based on the facts.
Yeah, I'm curious, just having worked with all the multiple different populations. I'm just curious, when somebody does have a guardianship, given certain circumstances, and then potentially move past that to where they seem like they would be capable of not having a guardianship, what would their steps be?
Great question. So first place I would always say is talk to the guardian. Going to court, the law allows us to go to court, but that should never be the first step. The first step should be figure out who's there and can we resolve, if there's an issue, can we resolve it internally first? So go to the guardian and say, I think this needs to be adjusted. And then the guardian conservator, we have to use both terms now. Yes, I think I agree with that. No, I don't have, I disagree with you. And if there's a question, then I think that's when you take it to the court and the court helps to decide. So an example of this. That I was involved in is an individual was subject to a guardian due to a major medical situation. And they got better. And then at that point in time, the guardianship needed to be removed. It needed to be concluded because that individual now was in the driver's seat. So that's a very clear example of, okay, we had a guardianship, it was needed for this particular reason, but that reason has now, it's stopped. So start with the guardian, and then from there, if they're not getting what they need, then probably look to the court.
We have a question online about substituted decision-making agreement. How can that be done or started?
Yep. So that is provided by statute. There is some other resources online if you want to look to that. But because of the cautionary tale that I put out there, I would probably recommend that you touch base with somebody, an attorney, or somebody who is familiar with those agreements and kind of walk through the fact-intensive decision of, is this the best way to go? What is the reason we're doing this agreement? Is this going to fit our solution? And I think I had it up there as a substituted, the supported decision-making is the model, as the agreement that we have in the statute.
So when there's a hearing for guardianship or conservatorship after the court visitor has been there, is that like, does the judge make a decision then, or does he just collect information, he or she, and then make a decision later?
Great question. So invariably, if all the facts are clear, the judge will make a decision at that hearing. However, sometimes the facts are not clear. Maybe the guardianship is contested. Maybe we have to have an evidentiary hearing. There's reasons why they might take it under advisement. That's the term if they don't decide right away. But invariably, with most of the guardianships we're talking about in this type of community, we've provided the facts to the judge and the court visitor has made a recommendation. And generally the courts will give a lot of credence to the court visitor's report and follow their recommendations unless there's something further that they need guidance on. Okay, excellent. Well, if there's any other questions, I'll be around afterwards. Please feel free to stop me. I have some cards out there, some pens. Any other questions? I'm happy to help. Thank you so much for your time tonight. Thank you for showing up. There's, I think, tons of pizza over there. Help yourself. And thank you again for your interest in this topic. Thank you.